Law of Tort. Occupiers Liability Part 2. Occupiers Liability Act 1984. The Occupiers Liability Act 1984 imposes a duty on occupiers in relation to persons other than his visitors under Section 1(1)(a). This includes trespassers and those who exceed their permission. Protection is even afforded to those breaking into the premises with criminal intent. For example, in Revel v. Newbury, the defendant had to pay damages when he shot an intruder to his allotment from his shed. Whilst it may at first appear harsh to impose a duty on occupiers for those that have come onto their land uninvited and without permission, liability was originally recognized at common law for child trespassers where the occupier was aware of the danger and aware that trespassers, including children, would encounter the danger. This position was established in British Railways Board v Harrington, where a 6-year-old boy was electrocuted on the train track when he took a shortcut to get to a play park. The train company were liable as they knew children used the shortcut and did not prevent this. The meaning of occupier is the same that applies to the 1957 Act. The test of occupational control applies from Wheat v Laken, where both the manager and the landlord of the pub were classed as occupiers. Physical occupation is not required according to Harris v Birkenhead. The Occupiers Liability Act 1984 applies a lower level of protection. The Act only covers death and personal injury. Occupiers have no duty in relation to the property of trespassers. The duty of care only arises when certain risk factors are present. The circumstances giving rise to a duty of care are set out in Section 1(3). An occupier owes a duty if a. He is aware of the danger or has reasonable grounds to believe that it exists. b. He knows or has reasonable grounds to believe the other is in the vicinity of the danger or may come into the vicinity of the danger. c. The risk is one in which in all the circumstances of the case, he may reasonably be expected to offer the other some protection. If all three of these are present, the occupier owes a duty of care to the non-lawful visitor. The criteria in Section 1(3) must be determined having regard to the circumstances prevailing at the time the alleged breach of duty resulted in injury to the claimant. In Donahue v Folkestone Properties, the claim failed as it was not foreseeable that someone would dive into the sea at midnight on Boxing Day, whereas it may have been foreseeable on a hot summer's day. Section 1(4) provides the duty is to take such care as is reasonable in all the circumstances of the case to see that the other does not suffer injury on the premises by reason of the danger concerned. The duty may be discharged by giving a warning or discouraging others from taking the risk as stated in Section 1(5). This differs from the duty under the 57 Act, where the warning must be sufficient to enable the visitor to be reasonably safe. The defense of volenti non fit injuria is applicable under Section 1(6). This states no duty of care is owed in respect of risks willingly accepted by the visitor. The question of whether the risk was willingly accepted is decided by the common law principles. Damages may be reduced under the Law Reform, Contributory Negligence, Act 1945 where the visitor fails to take reasonable care for their own safety. Whereas the 1957 Act allows an occupier to exclude liability, subject to the provisions set out in UCTA 1977, the 1984 Act does not expressly confer such a right. In summary, an occupier owes a duty of care to persons other than lawful visitors. This is a basic level of protection and only covers death and personal injury. To incur liability, the occupier must be aware of the danger on their land, know or should know that the other is in the vicinity of the danger and that it is reasonable in the circumstances to offer some protection. The duty is to see that the other does not suffer injury. This video is part of a series of videos on tort law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel, www.youtube.e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. Thank you for watching.